the way you're feeling right now, I hope that that's part of learning the lesson. Mr. Shores, can you come on your camera and microphone?
Yes, I can, Judge.
There we go. Thank you. All right. And then, of course, rescind that prior order for the warrant. Now, Mr. Shores, you're here today for your probation review on your reckless endangerment probation. And the reason
Yes.
that we summoned you in is because we got information that you potentially violated your probation, and that violation occurred with a reckless driving charge and conviction in the Thurston County Superior Court. Okay, does that ring a bell with you?
That is correct, Your Honor.
Okay. All right. There's more.
Your Honor, so, I mean, Mr. Shores entered a plea of guilty on the 1st of this month on that matter, so I'm not, I guess it seems redundant to say, I assume the court is going to find a violation, and I have discussed briefly with Mr. Thompson and then advised Mr. Shores on possible sanctions. Yes.
Okay. Well, I think we can safely say now that the violation is established. So, Mr. Thompson, what does the state think?
The state's asking the court to impose 45 days in custody, Your Honor, and that seems extreme on its face, given that he pled guilty to a reckless driving in Superior Court. But I will note for the court that it was originally charged as a felony elude. The defendant was given a PBT on the scene. And I did provide defense counsel access to the probable cause for that case. The defendant was given a PBT and blew a .05 at the time.
I understand it may be admissible in this setting. I would still object to the PBT.
Oh.
What?
All right, I will wait for instructions.
And I will note that the officer noted the odor of intoxicants, specifically alcohol emitting from the defendant's breath. The officer did note he did not smell any marijuana from the defendant's person. During the interaction with law enforcement, he did not observe watery, droopy, or red eyes. His speech and balance were decent and field sobriety tests weren't performed due to him being under arrest for elude. The initial stop was based off the defendant's failure to have his lights on. The defendant then eluded following that. The defendant was required to find him, was a canine track to the defendant's house. Again, I indicated that based off some of the indications, law enforcement did provide a PBT on the scene, and he blew a .05 on the PBT. While the state's not asking the court to make a finding of a particular level of intoxicants, the fact that he blew a .05 on a PBT does indicate consumption of alcohol, which he is expressly prohibited from doing while on probation for this case.
I would again.
What do you think I ought to do, Ms. Moore?
Well, Your Honor, I mean, I think the fact that Mr. Shores was able to, and his counsel were able to get the elude dismissed and negotiate this down to the reckless driving. He let me know that he's done a driving class. I believe there were some other affirmatives that went towards that. I also would not want, I guess I wouldn't want the court here to sort of let the state give the state jail time that they weren't able to get in Superior Court on a probation matter for another issue. But I understand that this is a separate thing where no law violations was a condition here. Mr. Shores has otherwise been compliant. I mean, there's compliance reports in Laserfish from treatment. And he also let me know that he's been working 12-hour shifts. I would ask that if the court imposed, like whatever sanction the court imposes, that he be allowed to serve on EHM, and that sanction be no more than 10 days.
Probation's, you've maybe heard me say this before. I say it sometimes. It's not a gotcha game.
Yeah.
We're not here to set snares and catch people, doing things when they fail to, check a box or jump through a hoop or something like that. Mr. Shores was placed on probation, was given affirmative obligations, he was given passive obligations, stay out of trouble, and so forth. And I'm looking at his ability to comply with those expectations, stay out of trouble, improve yourself, rehabilitate yourself so that things like what got him here don't happen again. So when Mr. Thompson tells me, the underlying condition was reckless driving, but then there's a fuller explanation that there was that circumstance where they originally pursued him, arrested him for eluding, noticed that there was alcohol, verified that with a PBT, that says that what was happening in that circumstance, regardless of how it turned out in court with charging, disposition, what have you, it's really similar to the original charge he was here for. So in that sense, Mr. Shores has not lived up to that expectation that he's going to improve himself and avoid being back here for the same sorts of things. And so that gives me concern. And Mr. Shores, I say those things because that just sort of characterizes the violations that you've committed. Okay. Now, I also recognize that it could be worse, right? I mean, you have done some positive things. You've clearly, from the reports we've received, you've tried to make things better, which is good. That's what we want to see.
Yes.
So it could be a total failure. It could be something that would alarm me that you didn't learn anything. It's not that, okay, but it is still serious. All right.
Yeah, I understand, Judge.
Yeah. So you have failed to a degree on your probation and significantly. So I am going to impose a sanction for that because it's appropriate to do that. Recognizing the quality of the violations here, not technical, not hoops, not traps. That's not what this is. So the original sentence was 364 days. That was all suspended back in June when you were sentenced, June of 2023. I'm going to find you're currently in violation for the reasons that I said, and I'm going to impose 30 days. And that 30 days needs to commence no later than September 12th, which gives you 3 weeks. All right, now I'm not going to let you serve that in any form of alternative confinement. You're going to have to do that in total confinement. Okay,
So I
that
have
means
to do
going to jail. Yeah, because we told you when we sentenced you that we were suspending your jail and that was conditional and you violated those conditions. So now you are going to have to spend some of that time in jail.
There's no possible way I could get home monitoring for 60 days, 90 days.
No, nope, that would not be the same. And Mr. Shores, the way you're feeling right now, I hope that that's part of learning the lesson about the importance of following through and following the law. Okay, you put people at risk when you do stuff like this. I'm concerned about your rehabilitation, but I'm also concerned about the safety of the community. Those are the things I have to be concerned about. Okay. And the way I think you learn that lesson in this context is you do some time in jail.
I
All
have
right,
two.
you got till September 12th to get started on it.
Yes, Judge.
All right, that's all for today, Mr. Shores. I think Mr. Dart found his way back.
It looks like you did, yes, Your Honor.
Okay, and Mr. Dart, can you turn on a camera and microphone for me, please?